Mema ubi biara akwaba biemba Odeneho TV so sene any dedican wo hwe me amesre se obe like na subscribe na share video no ede ama afofo na bibia etimi akoyi ede ama ye nebusua eye the removal of Chief Justice Torkonu na ehun sensem no enya nkoda ye na afi na court aye na adwen se oba ababetina se na busua ye na ye wo hanu se na ye JDM ede eye letter tintintintin bi ba abontin kire se opese oyi Chief Justice na nkrofo na amanu kwan se onyi nu na onfa obi fufuro embra na ombesisu na sansem we nso no yedi kan de abremu a na chese efi na court aye omadwen se omobetena se na omado nsem we mu esuko na Lawyer Paul Adom Okyere na beji akunya na wetimi apense nsem we mu na odi abregana fo nyina na se omohu dia omode nsem we nyina ene dia ebe nyina akwakoto bibia na ebiana omobeyinu anase omunyinu na nyina no ne na omode sansem we nyina ebeba abetu abontina imensa wo mrani ebeko ni akwakoti Lawyer Paul Adom Okyere abontin edikan medawase
will be confronted with a big issue. Who are the lawyers? The former Attorney General, the famous Lawyer Paul Adom Okyere, and the new Attorney General, who is former Deputy Attorney General Dominic Ayeni. The two lawyers have had some exchange of words and exchange of documents in terms of shredded documents here and there. But that's not the matter before the Supreme Court on Wednesday. Before the Supreme Court on Wednesday, it's a serious constitutional matter. Lawyer Paul Adom Okyere will be alleging that Article 1466 of the Republican Constitution, which governs the impeachment of a Chief Justice, has been violated by the processes undertaken by the government of John Dramani Mahama. Dominic Ayeni will be defending the position of what John Mahama's government has done. It's all about Gertrude Torkonu, Araba Torkonu. Will she remain as the Chief Justice of Ghana, or will there be an impeachment process that will take her out? That's the matter that confronts the Supreme Court. But beyond that, there's something more. We're going to tell you the details of what really confronts the Supreme Court on Wednesday. So what's the Supreme Court going to look at on Wednesday? On Wednesday, an important matter confronts the Supreme Court. What is it about? A petition has come from a Ghanaian to the President of Ghana. The petitioner is asking that Gertrude Araba Torkonu, the Lord Chief Justice, be removed from office because she's done something wrong. We all don't know what's in the petition yet, but of course, Gertrude Araba Torkonu now knows what's in the petition. So this is the matter. Now, Article 1433 of the 1992 Constitution outlines what should happen when a Supreme Court judge or an Electoral Commission or an OSP, any other person, is to be impeached. The person who wants the impeachment, which is the petitioner, writes a letter to the president, say that this person should be impeached as a Supreme Court judge. In the circumstances of the constitutional provision, the president, in those circumstances, is a conveyor belt. He sends the petition to the Chief Justice. The Chief Justice will make what the lawyers call a prima facie decision. That is to say, whether the person against whom the petition has been made has a case to answer. Now, the Chief Justice makes that determination, the prima facie determination, by inviting the person against whom the petition is made to make a response to the petition. So the Chief Justice receives the petition from the President, then he sends it to whoever the Supreme Court judge, whoever the petition is against, and says, this is a petition against you. They are saying that you have done X and Y. What do you have to say? The person writes to the Chief Justice, and then the Chief Justice looks at what the person has written and looks at the petition and makes a determination whether the person petitioned against has a case to answer. If the Chief Justice comes to the conclusion that the person against whom the petition is written has a case to answer, the Constitution provides what he or she should do. The Constitution provides in Article 143 clause 3 that the Chief Justice will now form a committee. The Constitution actually goes ahead to name who should be on the committee. In that case, there are two Supreme Court judges that the Chief Justice will select, excluding herself or himself, of course, selects two Supreme Court judges and three other people who are not lawyers or are not members of the Council of State. The five of them will sit together and the petition will be heard. How is the petition heard? The person who has written the petition, with his lawyer or without his lawyer, will be made to confront the person against whom the petition has been written, with his lawyer or without his lawyer, as he may prefer. After they have finished the deliberations, they will make a decision whether the petition should hold or the petition is dismissed. If they make a decision that the petition should hold, or if they make a decision that the petition is dismissed, whatever decision they make is final. That decision will be communicated to the president, and the president is expected to act upon the decision that the five have taken. Now, there's another twist to it. All of this, the Constitution says, or the Constitution prescribes, or the Constitution directs that all of this should be held in camera. That is to say, no media, no video, no camera, no telling of what happened, no telling another person, no complaining, and significantly, no filing of processes in court against the process. That's very important. So that's in Article 1433. Then when you come to Article 1466, it says that where the petition is against the Chief Justice, and this is very important because in 1433 is the Chief Justice who is running the show. He gets the petition or she gets the petition, decides whether there's a prima facie, sets up the committee, hears the committee, and then communicates to the President that, Your Excellency, the committee came to the conclusion that the petition holds, so please go ahead and fire this person, sack this person, whatever the committee said the President should do, they will do it. If the committee dismisses the petition, they will tell the President that the petition is hereby dismissed. Okay, in Article 1466, the Constitution says that where the petition is against the Chief Justice himself or herself, then he, the Chief Justice, or she, cannot participate in the process the same way it is for other Supreme Court judges, because the President cannot send a petition against her to herself and say, Madam, there's a petition against you, see whether there's a prima facie, tell her, think of your response in your head and look at the petition and say there's a prima facie. No, that's absurd, so that doesn't happen. The Constitution says that in that case, the President of Ghana and the Council of State will make the determination whether there's a prima facie case for her to answer. Now, if that determination is made for the Chief Justice to answer, the President and the Council of State will go ahead and form the committee with 2 Supreme Court judges and then 3 people who are not lawyers. They are not lawyers and they are not members of the Council of State. However, when the petition against Justice Akwa came up, it became, Justice Akwa was a Chief Justice of Ghana under John Ajekunku, forgive me, I should have said that. Justice Kingsley Akwa, he died, may he rest in peace, former student of Adisadel College. Now, when the petition against Justice Akwa was made, it was novel, it was new, and there was all kinds of legal arguments about it. How does this work? So, somebody called Ejechum went to the Supreme Court and told the Supreme Court that in the case of the Chief Justice, he is petitioning the Supreme Court that the prima facie cannot be done by the Chief Justice because the petition is about him. So the court, led by Dr. Dateba, made a strong case that it would appear that there is a gap in Article 1466 of the 1992 Constitution. That Article 1466 regulates the impeachment of a Chief Justice. So Dateba said, leading the court, is the majority opinion. I think it's a unanimous opinion, not a majority, unanimous opinion. Dateba said, leading the court, that where the matter is about the Chief Justice, it stands to reason that the Chief Justice cannot participate the way he or she participates in the 143 process. Therefore, the President and the Council of State must run the show. That means the President and the Council of State must make the prima facie decision. Now, to make the prima facie decision, the President and the Council of State must necessarily hear from the Chief Justice in a document. They would have to, the same way the Chief Justice does in Article 143, by sending the petition to whoever the petition is against. They, the President and the Council of State, would have to send the petition to the Chief Justice that, hey, Madam or Sir, this is a petition against you, what do you have to say? When the Chief Justice gives her opinion or gives her answers or whatever it is, that document forms part of the process by which the President and the Council of State will make the decision whether the Chief Justice has a case to answer. If they come to the conclusion that the Chief Justice has a case to answer, then they will set up the panel and then they will hear it, and the Chief Justice can be whatever, whether she will remain or whether she will go. That's the process. So guess what? A petition from a Ghanaian went to President John Dramani Mahama.